taught by Professor David Simon, Human Fund Endowed Chair in Law and Ethics at Yada Yada Law School, and Visiting Associate Professor and Frank H. Marks Intellectual Property Fellow at George Washington University Law School. Q&A for this class will be moderated by Professor Derek Muller, Keith Hernandez Professor of Law at Yada Yada Law School, and Professor of Law at the University of Iowa College of Law. Professor Simon, over to you for Seinfeld Torts.
Thank you, Dean Schill. I appreciate the introduction. My name is David A. Simon. I am the Human Fund Endowed Chair in Law and Ethics at Yada Yada Law School, and today we'll be talking about tort law. As Dean Schill mentioned, we do have a partner, Legal Services NYC, a nonprofit for which we're raising money. And as he mentioned, if you donate $20 before July 16th at 8 a.m. Eastern Time, you'll get a ticket to this private event, which will not be live streamed elsewhere. We've been doing great. We have a lot of donations so far, and we're hoping to add to that total. Just a quick introduction about myself. I'm currently a visiting associate professor and Frank H. Marks Intellectual Property Fellow at George Washington University Law School. I will be teaching trademark law there, but my interests are in torts, intellectual property, health law, and law and philosophy. If you'd like to follow me, my Twitter handle is David__Simon. So what's today about? Today is a class about something taught through a show about nothing. The question is, what is the something we're going to be talking about? That something is tort law. And I want to use Seinfeld today to achieve 2 and potentially 3 objectives. The first is to give you a broad overview of what a tort is. The second is to explain some reasons why we have tort law. And the third is to try and illustrate some of the concepts that we talk about using specific episodes in Seinfeld. So the first question is then, what are we going to talk about? We're talking about torts. What is a tort? Well, many people think that it's a dessert, and it isn't, and it also is, because we're not going to be talking about the kinds of things you eat after dinner or after lunch or even after breakfast, but we are going to be talking about things that implicate moral desert. What people deserve. Do they deserve to be punished? Do they deserve to be held liable? Tort law takes account of some of these things. So then what is a tort? If you're a law student, you know this already, but if you are thinking about law school, what you'll learn on the first day of your torts class, hopefully, is that there are generally 3 kinds of torts: intentional torts, accidental torts, and strict liability torts. So intentional torts are those torts done either with the conscious objective of achieving some result or taking some action with the knowledge that a particular result is substantially certain to follow. So just to give you some examples of intentional torts, there's an episode, the reverse episode, where the Seinfeld episode is done in reverse chronological order, and it involves FDR. Franklin Delano Romanowski. Now, Franklin Delano Romanowski wishes upon a star for Kramer to drop dead. And Kramer desperately wants to undo this wish because he doesn't want to drop dead. So one of the things he does is he lets FDR throw a snowball at his face. So this could be an example of an intentional tort, right? FDR throws the snowball at Kramer's face. And the purpose of doing that is to cause the snowball to hit his face. Okay, so that would be the tort of assault and battery, the torts of assault and battery, intentional tort. But torts, there are other kinds of intentional torts as well. So if you remember the episode in which Kramer and Newman hatch a scheme to redeem bottles for deposits, but they figure out that they can get more money if they redeem them not in New York, but in some other state. And so what do? Well, they use Newman's mail truck to transport all of these bottles to a neighboring state. Now, what's the tort here? Well, they took a piece of US government property, the mail truck, and used it for some other purpose. So in doing so, what did they do? They deprived the US government of the use of that property and committed the tort of trespass. And that's an intentional tort because even if they didn't mean to deprive the US government of the use of that property, they knew to a substantial certainty that by taking the truck, they would deprive the US government of that property. So those are two examples of intentional torts. The second kind of tort is accidental torts. And this is what most people think of when they think of torts. Slip and falls, car accidents, pretty much any kind of accident you can think of. That's what we'll call in torts negligence. Okay, so just to give some examples from the show, there's so many examples to choose from, but so if you remember in one episode, Kramer uses his corporation, Kramerica Enterprises, to hire an intern from NYU, Darren, pictured here. And Kramer's got this great idea, right? What he says is, look, Jerry, I want to build a rubber bladder that can go in oil tankers. And the purpose of the bladder is when an oil tanker hits an iceberg or some other piece of land, instead of the oil spilling directly into the ocean, the rubber bladder will prevent the oil from spilling. So Jerry says, you know, that's actually not a bad idea. And he gets Darren to help him test his bladder system. Well, how do they propose to test it? They're going to drop a giant ball of oil out of the Play Now headquarters. So Play Now is where George works. It makes sports equipment. So this picture here shows Kramer and Darren lifting the giant ball of oil and throwing it out the window. It ends up hitting Jerry's girlfriend and spilling oil all over her. So a potential accidental tort. They didn't mean to hit Jerry's girlfriend. If there was nobody on the street below, there wasn't a substantial certainty that necessarily it would cause an injury. So accidental tort. Perhaps a more clear example is the operation, where Kramer and Jerry are viewing an operation of a friend, and Kramer's offering junior mints to Jerry. He says, take a junior mint. He says, I don't want them. So they can be very refreshing. I don't want them. And he goes like this, and a junior mint flies out of the box and falls into the patient. Okay, in that particular case, the patient actually gets better, but had the patient, died from the result of the junior mint in his bodily cavity, that would be an accidental tort, right? Nobody meant for it to happen. It just sort of happened. Then there's strict liability torts. Now, strict liability torts are different from intentional and accidental torts because it doesn't matter how careful you are. It doesn't matter if you intended to achieve some result. You're going to be held liable if your product, let's say, doesn't perform as it should. So you can think of one example from Seinfeld, pretty well-known example if you're a Seinfeld fan. George buys envelopes for his wedding invitations. It turns out that the glue on the envelopes is toxic. Susan spends all day licking these envelopes, and then she dies as a result. So the question is the product defective? And if it is, then whoever manufactured the product could be liable for strict liability tort. Okay, so that's the general overview of what kind of torts there are, the kinds of things that tort law deals with. The next question then is, well, who does a tort happen to? Generally speaking, we can divide up the classes of victims of torts, the things that the people or the entities that torts happen to, into two classes. The first is individuals. That's pretty easy, right? The snowball hitting Kramer, Kramer gets hurt. Susan licking the envelope, Susan dies. Elaine gets bit by a dog who she thinks has rabies. She has physical harm. But other entities can also be the victims of torts. And it doesn't have to be physical injury to a person that is the basis for a tort. So in the case where Kramer and Newman take the mail truck and drive it across state lines to redeem bottle deposits, the potential the potential plaintiff, the person who's going to sue for the damages, could be the US government. It also could be a business, right? There's an episode where Kenny Rogers Roasters opens up across the street from Kramer's apartment, and it puts up this big red sign. And the sign itself is projecting red rays into Kramer's apartment. He can't sleep, right? He can't eat. He's just going crazy. There's a potential tort to him, but we're not. That's not what I'm going to focus on here. So he puts up a sign that says "bad chicken," right? So there could be a potential reputational claim by Kenny Rogers Roasters against Kramer. You know, he's saying something that's not true about their business. It's hurting their business, and so they might be able to sue. Now, if you're an individual, you can suffer different kinds of harm, right? You can suffer physical harm, like when FDR pelts Kramer with a snowball. You can suffer emotional harm when, although this doesn't happen with George, he's actually elated when Susan dies. Most people who suffer the loss of a loved one will feel some emotional harm, and that can be compensated by tort law. If somebody's injured, they can miss work, they can recover wages, their medical expenses, and other kinds of treatment expenses. So there's one category of harm occurs to individual person, and then there's another kind of harm that occurs to property. So we already saw that that Kramer and Newman, when they take the mail truck across state lines to redeem bottles, perhaps have committed a tort against the US government, and that potential tort was as to property. They deprived the owner of that property from using the use of that property. It can also, tort law can also compensate owners of property that are individuals as opposed to businesses or governments. So there's one episode where Kramer goes with a woman named Naomi, his girlfriend at the time, who likes to scratch his back with her long nails, to Susan's cabin. Now, Susan's parents built this cabin, and it's very important to her. And Kramer goes there before George and Susan and Jerry and Elaine get there, and he starts smoking his Cuban cigars. And then he decides that he's going to go down to the water and take a swim with Naomi, but he leaves a cigar on the mantle of the fireplace. It falls and catches fire on some newspaper, and the cabin burns down. Okay, so here there's been a harm to Susan's property that tort law is going to recognize. And also, in addition to property, as I was alluding to before, either people or businesses can suffer reputational harm. So if you remember the cockfighting episode where Kramer trains little Jerry Seinfeld, the rooster, to fight Marcelino's rooster. This is Marcelino over here. Well, at the beginning of that episode, Jerry goes to Marcelino's bodega, and he finds that his check is posted for insufficient funds. He tries to pay Marcelino to take the check down, but he won't. And so maybe Jerry could have some kind of a claim against Marcelino for reputational harm. Not a very good case, but potentially you could see how he might have that. And again, bringing our focus back to Kenny Rogers Roasters, Kenny Rogers Roasters might have some kind of reputational claim against Kramer for defaming its business. Now, one interesting side note, if you're thinking about law school or maybe you're in law school, is that tort law actually includes or started in the early days to protect reputational the reputation associated with names of products. So there's an area of intellectual property law called trademark law, which protects essentially the name associated with a product. That's a very rough and wrong description, but just so you kind of get the idea. That started as a cause of action in tort and sort of grew out of that into its own separate body of law. Okay, so we've seen that there's three different kinds of torts. That torts, the victims of torts, so to speak, the people who suffer the harm can be individuals, businesses, the government, and that they might suffer personal harm or harm to their property or reputation. Now I just want to say a word about a negligence. So remember the three kinds of torts. There were intentional torts, accidental torts, and strict liability torts. So what I'm going to try to focus on for most of today's lecture is negligence. So negligence is all about accidents. It's another way of saying accidental torts. And if you want to show that somebody was negligent and therefore they should pay for the damages that they caused, you have to show four things. You have to show that the defendant, the potential tortfeasor, owed you a duty, that they were supposed to do something and they didn't do it. Then you have to show that they breached that duty, that they actually didn't do what they were supposed to do. Yes, they had a duty. Kramer and Darren had a duty to make sure that there was nobody below before they dropped the giant ball of oil. Kramer had a duty to make sure he put out his cigar before he left to go to the lake, and that he didn't do that. And if you can show those two things, if you can show that the defendant owed the plaintiff a duty, owed you a duty, and breached that duty, then you have to make sure that by breaching that duty, that's what caused your injury. So the fact that Kramer didn't put out a cigar, and that was what caused the fire that burned down the cabin, shows us that, yeah, he breached the duty, and as a result of breaching that duty, he caused the damage to the property. So you have to link the breach of the duty to the injury, and you do that through causation. So you have these four elements you always have to prove when you allege a negligence claim: that the defendant owed you a duty, that the defendant breached the duty, that by breaching the duty, the defendant caused an injury. Okay, strict liability is a little bit different, and I don't know if we're going to get to much of this in today's lecture, but we might. Strict liability just says you have a duty to make a safe product, let's say. And if you don't put out a safe product, you're liable, no matter how careful you were. So in a negligence cause of action, it matters how careful you were, because the duty that's imposed on you is one of the reasonable person. What would a reasonable person do in that circumstance? In the case of strict liability, it's not about reasonableness. You either put out a safe product or you don't. If you put out a safe product, you're not going to be liable. But if the product explodes, it's got a defect, then you're going to be liable. It doesn't matter how careful you were in making the product. Okay, so we've gone over negligence, strict liability, and we may or may not talk about defenses. There are defenses that defendants can mount to negligence, and we may or may not talk about some of those. Now, before illustrating some of these concepts through Seinfeld, I thought we'd just take a moment to discuss why we have tort law at all. Right? We've seen what it does, we've seen when it acts, but why do we have it? And there's three general reasons why we have tort law. They are compensation, deterrence, and punishment. So what is deterrence? Deterrence is the idea that if you put a penalty in place, people will be less likely to engage in the conduct that's penalized. So one of the purposes of tort law is to deter people from engaging in risky conduct or harmful conduct. And there's two kinds of deterrence. There's specific deterrence, where you're trying to get a specific person or a specific kind of person not to engage in conduct. And there's general deterrence. You're just trying to deter that activity in general. And deterrence is a concept, although that is central to tort law, shows up in a lot of other areas as well, contract law, including criminal law. So it's a concept you should be familiar with if you're thinking about going to law school or doing something in the law. The second purpose of tort law is compensation. So if somebody gets hurt, the tort system is designed to compensate them for getting hurt, provided that they got hurt as a result of, say, the negligence of the defendant. So if you think about the cabin case, the case where Kramer leaves the cigar and it ignites the cabin and burns it down, we want to make Susan whole. We want to compensate her in some way for her loss because Kramer was negligent in leaving the cigar out. And we do that mainly in tort law by giving monetary relief. We give money. And so much of tort law is designed to try and use money to make people whole for injuries or insults or damage that they'll never be made whole for. But really, that's the only tool we have, and so that's what we use. And then finally, there's an element of this, although it's not universally agreed that this should be a function of tort law, but one of the functions of tort law also can be to punish. So remember I said at the beginning of the lecture that tort law is about deserts, not deserts, but sometimes it's about desert. So sometimes it's about punishing somebody because they did something that was wrong. Not necessarily even legally wrong, but morally wrong. And oftentimes this kind of punishment occurs when the defendant has repeatedly showed that they know about something that was harmful to a particular person or a group of people, and they just didn't care. They just went ahead and did it anyways. And so, you might think like the tobacco companies are a good example of this. So remember, there's a case, there's an episode where Kramer starts having a smoking night. And I'm going to talk hopefully a little bit about this episode later in the lecture. And he basically has all these people in his apartment for like 12 hours, just constantly smoking and having fun and drinking or whatever. And at the end of the next day, he looks like this. So he goes to Jerry's apartment, and Jerry says, "My God, what's going on with your face?" And Kramer says, "What?" And he says, "It looks like an old catcher's mitt." And Kramer said, "Look away, I'm hideous." And so what's the issue there? Well, the tobacco companies, let's say they knew that smoking causes cancer, or that smoking was addictive and it caused your skin to change its complexion and cause visual deformities. Well, if they knew about that and they were marketing it as like a health product, then maybe they deserve punishment. Maybe they deserve punishment because they were morally wrong, or maybe they deserve punishment for deterrence. Maybe we really, really, really want to get them to stop doing this kind of marketing, and the only way we can do that is imposing huge monetary damages. Sometimes tort law will do that too. Okay, so we've talked about sort of what tort law is, what its purposes are. Now I just want to say a couple words about where it comes from. So in some of the previous lectures, talked about constitutional law. We have the Constitution. Talked about the federal rules of evidence. Well, we have the federal rules of evidence. It's a document that's right in front of us. Well, where does tort law come from? Well, tort law is a little bit different. Tort law started with judges. Judges made it up, right? They were presented with cases and they decided those cases. And over time, the law accreted rules and they continued to use those rules to decide future cases. Now, over time, legislatures have invaded the tort space in some sense by enacting statutes that play into tort analysis. So in some states, there are strict liability statutes that basically say, these are the causes of action that qualify as strict liability. And so maybe displace the strict liability that had developed in the common law. There's also things called statutes of repose, where the legislature has specifically said, we're going to limit certain causes of action because of the nature of the activity. So frequent area statutes of repose are construction, and the statutes say something like, you can only sue for a construction defect within 5 years of construction. Whereas in the normal case of a tort action, you can sue, let's say, within 2 years of discovering the problem. So the legislature has tried to limit when plaintiffs can bring certain cases. There are also statutes limiting recovery. It's frequently known as tort reform. And often you'll hear people say, well, there's too many frivolous lawsuits and it costs too much money. But essentially what tort reform is it's designed to limit how much money people can get, no matter how bad their injury. So assume that you get into an accident, you lose your legs. The statute says, well, you can only recover $300,000. I don't particularly think that's a very good idea, but it is a way to limit costs. Not cost to the person still has the same cost, they're not whole, but it limits costs to insurers and other businesses and third parties. Right, and then finally, there's this way in which tort law can interact with statutes through certain doctrines. If there's a statute that says you have to go a certain speed limit, tort law will take cognizance of that. It will recognize that, yeah, that this could be a particular safety standard. And if you violate the statute, some courts will say this can be evidence of negligence, or it can be negligence just in and of itself, negligence per se. And if you're interested about reading about this interaction between statutes and tort doctrines, I have the site to an article here that's very helpful for that. Okay, so now I just like to spend the last 15 minutes or so talking about 2 or 3 examples that help illustrate some of these concepts in tort. So remember that I said I'd be talking principally about negligence, and that's what I'm going to do here. In general, the law doesn't want to impose duties on people for failing to act, right? We don't want to say that if somebody's drowning, you have to go get them, give them help. And you might think, well, that seems really weird. Don't we want to encourage people to go give help? Well, this has changed over time, but the general idea in tort law was for a long time, and to some extent still is, if you start imposing affirmative obligations on people to go help, you might end up causing more harm than you're preventing. Person might go try to save somebody who's drowning, and then both of the people drowned. The person might try to render aid to someone on the side of the road and instead cause a backup, a bunch of crashes on the highway, whatever it is. There's also something animating this act versus omission distinction about just our responsibility as people and what it would mean if the law started to tell us what we had to do in all cases, right? We generally think we're free to do what we want, but if we started imposing duties to act in all manner of activities, we'd be less free to engage in those activities. So I'd like to try to illustrate this concept using one of my favorite characters in Seinfeld. As you can see, I have my #1 dad shirt on. But in this episode, The English Patient, Jerry goes down to Del Boca Vista, where his parents live, and he goes to see his dad. He gives his dad this #1 dad shirt. He's got it for $1, and his dad says, Morty Seinfeld, this is the best gift I've ever gotten. Anyways, they go to the health club, and Morty Seinfeld says, this is the guy I wanted you to see, Izzy Mandelbaum. He's 80 years old, strong as an ox, right? And he says he can lift that up. And Morty says, you couldn't do that, Jerry. And he said, I could do that if I want. I just choose not to. And then there's a third gentleman there who says, hey, Izzy, he says that you can't lift this up. And he says, oh, yeah? And so he says, Izzy says to Jerry, let's see you lift it. So he lifts it up. And then Izzy Mandelbaum tries to lift a heavier weight. And, he says, it's go time. And he pulls it up and he hurts his back and he ends up in bed. Story doesn't stop there. They go to Izzy Mandelbaum's house and he says, I'm really sorry, Mr. Mandelbaum. And then Izzy sees Morty Seinfeld wearing this #1 dad shirt. He gets really upset. He says, oh, I see. You knocked me out of commission, so you can strut around in your #1 fancy #1 shirt. And so then he tries to get up again and he hurts his back. And then, of course, he goes to the hospital and the same thing repeats where his sons show up and they think that Jerry's trying to outdo them and they try to lift something. One of his sons shows up, tries to lift something, he gets hurt. Then his father shows up, he tries to lift something, he gets hurt. It's the same thing over and over. So how does this relate to the act-omission distinction? Well, think about this in the context of Yania, right? The Yania case involved a person who owned a mine, asked for the plaintiff to come to the mine to help with something. The defendant starts taunting the plaintiff to jump in the mine pit, which was filled with water. The plaintiff does that and he starts to drown. The defendant doesn't come to his aid and he dies. And the court says, no, look, the defendant's not under an obligation to go save this person because he wasn't responsible for creating the harm. He's not under a duty to take some action because he didn't do anything to cause the harm. So the question then is, in The English Patient, did Jerry do anything to cause the harm? Did Jerry egg on Izzy Mandelbaum? Well, maybe he did, maybe he didn't. But in Yania, the court was very clear that just merely saying something doesn't make you responsible for an action, and therefore you don't have any legal responsibility for either jumping in the pond or thereafter going to rescue him. So in this case, it seems like Jerry's not going to be responsible for Izzy Mandelbaum's independent decision to lift the weights. And he also wouldn't be responsible for rendering aid to Izzy Mandelbaum in such cases, even though they called an ambulance. He said, call an ambulance. I think there's already one here for Miss So-and-so. Although there's this one sort of wrinkle here. In Yania, the court says that if the person is a child, if the person you're egging on to do some action that ends up creating a danger is a child or is mentally incompetent, then there could be a case that you had a duty to render aid. So the argument that Izzy Mandelbaum would have to make would be that, look, I am mentally incompetent and it doesn't seem like he qualifies there, although he's a very strange person. Sorry, I should have shown that slide, but I skipped over that. So then the second concept I wanted to talk about was res ipsa loquitur. Res ipsa loquitur has to do with duty. And how do you show that somebody breached their duty? Remember, for negligence cause of action, you have to have duty, breach, causation, and injury. So you have to show there is a duty, which is sort of what the last slide was about, act versus omission. Now I'm talking about how do you show that somebody breached a duty? Well, oftentimes there will be evidence, right? There'll be a car accident, maybe there'll be a videotape, there'll be eyewitness testimony, there'll be evidence about what happened. But in some cases, there won't be evidence. Something will happen and the plaintiff won't be in a position to figure out what happened, what the defendant did or didn't do. It just seems like the defendant did something wrong. So the episode that I chose to illustrate this with in Seinfeld is the glasses. So here, Kramer gets Jerry the Commando 8, which is an air conditioner. He brings it over the window. He says, puts it down and leaves the window open and then closes the blind. The blind just hits the top of the air conditioner and he says, installed, right? So it's not installed properly, obviously. And then later on, as you can see from these pictures here, it starts to wiggle and falls out of the window. Kramer tries to get it by the extension cord or by the power cord. That breaks and it falls and it hits a dog. So what's the problem here? Well, if you're the dog owner, let's say, you don't have any evidence about how the thing fell, right? You have to get some evidence about what the defendant did wrong. Well, Kramer didn't install the air conditioner properly, but let's assume that nobody in the Seinfeld crew is willing to testify. So there's really no way for the defendant to show that the plaintiff to show that the defendant did anything wrong, right? That's pretty similar to the case of Byrne versus Bodle, where a drum fell out of a warehouse, a barrel fell out of a warehouse window and hit somebody walking below on the sidewalk. The plaintiff had no way to show that the defendant actually did something wrong, but nevertheless, the court says, we're going to let you get to the jury. We're going to let you argue to the jury that the defendant breached a duty. Why? Well, for three reasons. Like the nature of the accident itself suggests that there was some negligence. Barrels just don't fall out of buildings. Just like with the case of Commando 8, air conditioners generally don't fall out of windows. If they did, we'd have a lot more injuries. It would be very, very bad. Why else? Well, the instrumentality that caused the injury was under the exclusive control of the defendant. In Byrne versus Bodle, right, nobody else had control of the barrels. So it had to be the case that the defendant was responsible for those barrels falling out of the window. Similarly, you can make an argument that nobody other than whoever was in the apartment, whoever installed it, the air conditioner, had control over it, and therefore this doctrine of res ipsa loquitur should apply. And then finally, this doctrine operates when there's no direct evidence that the plaintiff can point to, when all of the defendants are just saying nothing. In Byrne versus Bodle, there was no evidence. In this case, we'll assume that none of the characters from Seinfeld are willing to testify. They say, no, nothing happened. We don't know anything about it. Right? If all three of those things are true, then the courts are willing to say, even though you can't show that the defendant breached their duty, we're going to let the jury decide based on the evidence that you do present whether they think the defendant breached the duty, even though there's no direct evidence of it. So it's a way for courts to let cases go to the jury as opposed to just dismissing them because there's no evidence of a breach of duty. So I think that I'll probably have to stop there so we have time for questions. I was going to cover some strict liability, but I don't think we have time. So just a reminder that the donation, it would be much appreciated for Legal Services NYC. And again, if you donate $20 by July 16th, I believe, then we will give you a ticket to this exclusive event. So that's all I have. Thank you.
All right, great. Well, thank you, Professor Simon. We have a number of questions, so we'll see how many of them we can get through in the next few minutes. First, there was a question on defamation, a question about putting out the sign saying "bad chicken." Is that actually a reputational harm? The question is that a statement of opinion as opposed to a statement of fact? Because defamation really turns on statements of fact. So I wonder if you could sort of run through a little bit of a defamation analysis, thinking about the Kenny Rogers episode.
Yeah, so for defamation, you do have to show several, you do have to prove several elements. One of those is that the statement you make is a statement of fact. And of course, you also have to show that the statement was made to a third party and that there was some harm that occurred as a result. Just saying that something is bad is probably not, enough, especially in this case, because there's just there's just nothing other than a sign that says bad chicken. He didn't make any claims that the chicken had bugs in them or that they were using bad ingredients or any kind of falsifiable claim. It's also not even clear that the sign had any effect whatsoever. So it's probably going to be a hard sell to bring a defamation claim.
Great. So back to negligence, there was a question arose thinking about causation and how causation works. Are there wrongs or are there harms that just simply have no cause? We could call them acts of God or something else. Like, does every harm or wrong that befalls someone get traced back to someone else, or how do we think about causation and harm?
Yeah, so if you're the plaintiff's attorney, you're certainly going to try to find human cause for a harm, but not all harms are compensable, right? If there's no individual or entity that's responsible for a harm, or even if there's no individual or entity that breaches a duty, then you're not going to be able to recover. And even if somebody does breach a duty, it might not be the relevant duty. So for example, suppose that there's a regulation that says, all food must be stored at 30 degrees Celsius, and somebody ships the food at 10 degrees Celsius, and the person eats the food, gets the food, and they get sick and die, but they get sick and die because there was a mouse in the food and it contaminated it. So the question is, well, let's say the duty was to ship the food at 30 degrees Celsius. Did breaching that duty, which they definitely breached, cause the harm? The answer is no. What caused the harm was some other action. They didn't have clean manufacturing practices or whatever. So you got to make sure that you tie the relevant breach of the duty to the harm that occurs. And I think that answered the question.
All right. So there was a question about acts versus omissions and thinking about affirmative duties. And so this was, specifically a question asking about, are there duties to intervene in dangerous situations? Like there's a car wreck, car's on fire, there are people still in the car, thinking about, are you liable? Do you have to intervene? What is this state by state? Or is it statutory? Like, what are the circumstances in which there is an affirmative duty to intervene? Would calling 911 be enough? Or what are the contours of sort of those affirmative duties? What do they look like?
Well, so some states have enacted Good Samaritan laws that require people to that exempt people from liability who do render aid. In general, there's not an affirmative duty to intervene. Like if there's a car accident on the side of the road, in general, there's not a duty to go and rescue somebody. And in fact, you can be accepting these Good Samaritan laws, you can be liable if you make the situation worse. And that's one of the reasons that tort law generally doesn't impose the duty. On the other hand, if you're responsible for causing the harm, or if you have a special relationship to the person, like it's your child or it's an employee, the law may impose a duty on you to do something. But the default rule is no, you don't have a duty to act. And the contours of this rule are shaped by state law. So it is, if you want to get down to the details on any specific question, you're going to have to go to each individual state.
All right, great. So we had a question about RESPs asking about duty, right? Is it a requirement that the plaintiff not have direct evidence? Or if the plaintiff does have direct evidence, does that change the situation, change how we view the res ipsa as sort of an element?
Yeah, if the plaintiff has direct evidence, then there's no need for the doctrine. So there has to be a lack of direct evidence. Otherwise, the doctrine's not really doing any work. It's really meant to capture those situations where we sort of know that they did something wrong, but we can't really show it because we don't have the relevant evidence.
Great.
So it's a requirement.
Yeah. So there's a question here. So there is actually in the links, there's a link to someone shared the Museum of Tort Law, which I believe is a Ralph Nader project. And there's a second Ralph Nader question that came along asking about his unsafe at any speed expose in 1965 about the automobile industry, saying the automobile industry knew about unsafe cars. They were designing these unsafe cars. And yet they went ahead and sold them anyway. So the question is, would this expose the auto companies to tort liability? Or is this a question of a different field? We can think maybe about, I guess, criminal law or something else. Is there an overlap of the relationship? What do we think about automobile design and sort of selling knowingly defective products?
Sure. So I just want to take something you said at the end of that question first, which is there an overlap between criminal law and tort law? And the answer to that question is yes. One of the key differences, there's a couple differences between those two areas, but one of the key differences between them is the standard of proof that's required to show somebody is criminally responsible versus civilly responsible. So the standard of proof is much lower in civil proceedings than it is in criminal proceedings, which requires proof beyond a reasonable doubt. So that's an important distinction. As far as what areas of law cover, defective products, generally speaking, that is the domain of tort law. I was going to talk a little bit about this episode, but I have a relevant slide to answer this question. So tort law originally started dealing with these kinds of products liability claims where the product is unsafe for its purpose, using implied warranty of general quality, which was a common law doctrine. It basically said that if you sell something to somebody, it's got to be safe for the purpose that it's used. And this is also embodied, incidentally, in Uniform Commercial Code and in contract law in Article 2. But there were some limitations that arose from this doctrine, like you had to be in contractual privity with the person you were trying to sue. So you could only sue the person who actually sold you the product, like in this case, the car dealer. You couldn't sue the manufacturer of the product. So tort law does deal with this now through products liability. And there's generally three kinds of products liability claims. There's manufacturer claims, defective manufacturer claims, defective design claims, and defective marketing claims. So defective manufacturing claims would be like, you made it in the wrong way. It's different from what you said it was. Defective design claims are, you've made it in a way that's unreasonably dangerous, that it's designed such it's going to cause some harm. And then defective marketing claims are sort of like the tobacco failure to warn claims. You marketed it in a way to paper over the risks of the product. So in a lot of products liability cases, including auto cases against auto manufacturers, plaintiffs' attorneys are going to use all three of these theories and probably also negligence theory. Because there is some overlap, even though they're different categories, strict liability and negligence, there is some overlap. So yes, tort law will handle these kinds of claims. And just to give you an example of why you might choose one theory over the other. So if you choose a negligence theory, like assuming we're just in a strict common law jurisdiction, there's no strict liability statute. If you choose a negligence theory and you can show that the product manufacturer was negligent and that they knew about some risk and ignored it, you might be able to prove gross negligence. And there you can get punitive damages, which means, the big money. You can really sock it to the defendant, and plaintiff's attorneys would be very interested in that for a variety of reasons.
All right, we're winding down. Let's see how many more we can get through. There's a question about in the English Patient episode, as the replacement crepe rollers show up into the restaurant. They roll the crepes too tight and they burn the patrons, right? So, it seems like potentially tort liability there. But there's a question here about who the liability might fall upon. Is it upon the business? Is it on the individuals who prepared the food? Is it both? What does that look like?
Right. So typically what will happen is the people rolling the crepes, let's say, would be employees. And if somebody is an employee and commits a tort within the scope of the employment, then the employer is generally going to be liable for that tort. So I hope that answers the question.
Yeah, great. So someone asked a question about is wrongly accusing a person of a crime, like trespassing, when the person didn't trespass. The DA dismisses the case at court. This kind of causes some harm to the innocent person who's been accused, right? It embarrasses them, whatever it might be. There's expenses and hiring a lawyer for this false claim. Is that actionable? Is there a tort harm there for falsely accusing someone of a crime?
There certainly could be, and actually you see this play out in the news recently. If you can show the elements of defamation, that somebody made a statement of fact that was false and that it was communicated to a third party and that it caused reputational harm, if you can show that, then you could potentially bring a defamation claim. But tort law is not going to just compensate people insulting each other or saying nasty things about each other. It doesn't recognize all kinds of harm.
All right, great. And there's one last question, which we'll see, which might test your comparative knowledge. We're talking about defamation. Someone raised sort of the Johnny Depp, Amber Heard sort of situation arising, talking about showing harm, requiring or what's required to prove defamation, and pointing out this is a situation that's happening right now in the British court system. Asking, I don't know the depth of your knowledge, so I save it for last. Comparing sort of how the British approach to defamation compares or contrasts with the American approach, or if not, we can bring it to a close.
I can say something about it. Since I did study there, they do have, and I know this only at the most general level, they do have a stricter approach to both the tort of defamation and right to privacy. And by stricter, I mean they're more willing to silence speech because they don't have a First Amendment. There aren't those same concerns, but that's about all I'm willing to say.
All right, terrific. Well, thank you, Professor Simon. Please join us next Wednesday at the usual time for a doubleheader on business law. And then, of course, on Thursday, the 16th at 5 p.m., please join us for a private event with Seinfeldia author Jennifer Armstrong. Chip in $20 by next Thursday morning if you're interested in participating. So thank you so much.